Hi, I'm Philip Hundl. I'm an attorney and mediator. My practice area focuses on mediating land disputes, and we're back with the final two top tips in successfully mediating a land dispute. So we've worked our way all the way from 1 to 8. Now we're at 9 and 10. These have kind of progressed in the manner in which chronologically, I think. Uh, and so we're at the point of um, you're in a mediation, and you know, and this video is directed at the attorneys probably for the most part, but even the parties that are related or parties that are involved in a land dispute, um, you've reached a deal, and it's been a long day, and you've reached a deal, and everybody's ready to go home. They really are. Um, they've had uh, the sandwiches brought in by the mediator, and and those were good at the moment, but now we're all ready to go. And you know, us mediators, we normally will provide lunch, but normally dinner that's not planned. Yes, if we're making progress and everyone is willing to stay, I'll bring in dinner as well. But everybody's ready to go. Um, Make sure and memorialize the agreement that's been reached in writing. It sounds like it's a no-brainer. It sounds like, of course that will be done at a mediation. And you'd be surprised that sometimes in an effort to get out, beat traffic, head home, don't worry, we'll do it tomorrow, um, you know, agreements aren't memorialized. And, you know, and that's, like I said, that's, you potentially wasted the whole day, especially when you've got a deal done and folks think that everyone's going to come back and sign it. Sometimes they do, sometimes they don't. So make sure that you get it in writing, accurately, properly, and most times in my settlement agreements that I kind of my boilerplate settlement agreements have standard, once again, standard mediated settlement boilerplate language that you know I I really expect that that the parties, the attorneys, will read those ahead of time. I like sending those out ahead of time and say, read this. This is a standard boilerplate, and then normally there's the customized section. Uh, it can be Exhibit A or addendum, but anyway, that's the part where it's unique and customizable to the case that we're mediating. Um, but make sure all the language in the boilerplate and even in the customized part accurately reflects the parties' agreement. As a mediator, I'm going to do my best to try to keep track of, here were the topics or items that were talked about in dispute, agreed upon, and I'm going to also kind of cross-reference the settlement agreement to make sure it accurately reflects everything that, you know, sounded like was agreed to by the parties. But make sure there are no loose ends. Make sure there are no omissions. It is later in the day typically. Everyone's a little tired, but find a corner, go to a room by yourself, attorneys, and review it without any distractions. Sure, are folks going to be talking, if you're in a room with your clients or with the opposing counsel? Could someone be distracting you, talking to you while you're trying to focus on? Absolutely. On purpose? No, probably not. But go and try to focus on the settlement document to make sure it accurately reflects everything that has been discussed and resolved. Um, Include provisions in if it's not in the boilerplate portion, what happens in a breach or an interpretation dispute? Are there for interpretation disputes? Who will the mediator act as an arbitrator to then make interpretations on the settlement agreement? Or are there other notice provisions if there's breaches by any of the parties? So make sure those things are included as well. um, go over that, attorneys go over that settlement agreement with your clients, and even allow them time to digest it, read it, understand it, so that, obviously there's, they may be able to notice and remember something that's been omitted, or something that's not exactly the way they understood the deal was reached, or the agreement. So number 9, don't leave yet, paper it up, okay? Number 10, and this is one of those where I love watching, the college football Saturday morning show, and one of the comments always is, not so fast, my friend. So step number 10 is, so you're done, great. You're going to close the file and call it a day. Attorneys, no, not so fast, my friend. So you've completed, you've got this settlement agreement. Make sure that the settlement agreement is complied, or it's completed by your client, or complied with by your client, or whatever is required of them. If something is required of them, make sure that's done. The last thing you want to do is, have a good, successful mediation, and part of the mediation is going to be your client's going to pay the other side a certain amount of money or whatever, or you, the lawyers, are going to finalize the easement document. You've got all the terms set out in the settlement agreement, but you're going to finalize that easement agreement, and everybody's going to sign. Well, make sure all those things get done. Very easy to, after mediation, we've all been there, is to set it aside. But I'll do that later, and later becomes 2 or 3 or 4 weeks. So make sure that attorneys on your end, things are done. Condemnation cases, what are some examples? So condemnation cases, make sure those releases of lis pendens are recorded. As we all know, in a condemnation case, most of the time a condemnor is going to record a lis pendens showing that there's a lawsuit, condemnation lawsuit related to this property. Make sure those get released. If we've got a partition, get those partition deeds recorded. If there's easements related to the partition, or easements related to an easement dispute, you make sure those get recorded. Or if it's memorandums of easements, lawsuits, get those dismissals or non-suits filed as well, or agreed judgments, you name it. On the, that's kind of on the attorney's side. On the client's end, if there's some payments that need to be made, I think I already said this, make those payments. If there's things that they are supposed to do, build a fence, move some dirt, build a road, you name it, specific performance type items, let's make sure that that's complied with. Last thing you want is to kind of, here we go again, and we're in a new lawsuit or new litigation, a breach of contract, breach of this settlement agreement. When there's changes of ownership, some kind of administrative cleaning up matters, is, hey, partition of this land, the Central Appraisal District had it as, these, 5 people, and now each one of them have their own separate track. So get with the Central Appraisal District. They will normally, I think twice a year, do a sweep of the deed records, and they would pick up that partition deed. But I strongly recommend doing land litigation, real estate litigation, and also as a mediator, suggestions that I've seen over the years is, contact the Central Appraisal Office, let them know, send them a copy of the executed and recorded partition deed, and say, hey, this one tract that was one property ID number at the CAD is now going to be 5, right? And so they can make that change. Be wary, right, of if it had ag value, or some people call it ag exemption, but an ag value, all of a sudden the CAD could switch it back to a market valuation. So be aware and be ready to, resubmit the application for ag valuation. If the use doesn't change. So different things that typically, the lawyer could do some of that, but that may be a client, task. And then enforcement of the settlement agreement, you've complied, you've done everything, but the other side hasn't. Well, there you go, right? Settlement agreement may provide where you give notice, hey, you forgot to make a payment, you forgot to do a task or some specific performance item, they need to do it or you'll be in breach. If there's some ambiguities or some interpretation needed, most of the time in most of my settlement agreements, it says the mediator would, if the parties agree, right, will arbitrate any disputes related to the settlement agreement. Or parties agree to go back to the mediator to mediate that dispute before filing a breach of contract. So number 10, not done yet, not so fast. Before closing your file, make sure all things are complied with, and definitely, pending litigation, it gets dismissed. So hopefully those tips are helpful. We've got this, bullet point or summarized in an ebook that is also available at my website. We'll have the website listed down below, so you can click on to the website. You'll get more information on mediation, alternative dispute resolution, and a little bit more about the process, this ebook with these top 10 tips for getting your land dispute resolved. Okay, good luck.